Visit bankofpeoples.com.
This is the Jim Polito Show on News Radio 560 WHYN.
It is the SCOTUS Bowl. The SCOTUS Bowl, yeah. Well, Supreme Court season is over, and Allison Cohen is here and giving us the winners, the losers, whatever, all the stats. And Allison, one of the most important cases, you discussed it many, many times with us. And it's a big case because of what it means going forward. What it means about the argument everyone makes about separation of church and state and the like. It's the Trinity case.
The Trinity Lutheran Church versus Poly case, yes. And this was a case that dealt with playgrounds, Jim.
Yep.
Remember, and this idea that you apply for a grant. Missouri had a grant application program where you could get reused tires, recycled tires on your playground. But because they were part of a church, they were denied an application. They had done everything right. They should have very easily gotten the money to be able to make a safe playground for the kids, but they were denied it because they were affiliated with the church. So they took a case up to the Supreme Court. The Supreme Court came out with a 7-2 decision this past week in which they said that clearly this program violated the free exercise clause of the First Amendment by denying the church an otherwise available public benefit. Why? On the account of their religious status.
Okay.
And that was a violation of the First Amendment free exercise clause.
That's incredible.
Right.
You would think in this day and age that something like that would not be allowed, and it was. And it makes perfect sense. Do you remember when George W. Bush came into office and he wanted to do social services through religious organizations?
Right.
And there was a lot of pushback on that, but it was, well, wait a minute. These charitable organizations are already set up, already have infrastructure. We don't have to reinvent the wheel. Faith-based organizations should be able to provide these services. This, to me, is actually simpler than that case. Now, of course, I'm not the legal scholar, you are, but to me, this case was simpler. It was they're asking for this from the government. What's the problem?
Exactly, and the way that Missouri was looking at it, they said that their constitution prohibits money from the state treasury going to, quote, directly or indirectly, or in aid of any church, sect, or denomination of religion. But the Supreme Court looked at that and they said that refusal really violates not just the First Amendment free exercise clause, but it also violated the 14th Amendment equal protection clause, because a state has to apply its laws equally. And in this case, it was treating the church differently because of the fact that it was a church.
Yeah.
And so it nonsensical, right?
Right.
Equal application of the laws. And so I'm very happy with the decision. Of course, it wasn't unanimous. It was 7-2. So who do you believe were the two people that had voted against it?
I can guess this easily.
Yes.
Ginsburg.
Yes.
And Sotomayor.
You got it.
Kagan, while she is very, very liberal, and
Right.
wasn't she ran Harvard Law.
Right.
Kagan sometimes can surprise you.
Right.
Not frequently, but in terms of the liberal wing of the court, I think Kagan surprises us once in a while.
I think she does too. And Gorsuch actually ruled in on this one. He did, so it was a true 7-2. But I was very happy. I think it's a significant case this term. We had followed it all the way through.
Yeah.
I think we've talked about it maybe 3 or 4 times throughout the year. So to me, it was a big win.
And now, going forward,
Right.
let's think about what this means.
Let's think about soup kitchens for a moment.
Yeah, let's think,
Because
right, we have,
all of these things that would have been associated with different programs, like with churches or synagogues, might have been shut down, might not have been able to have that specific additional pieces of funding had this case turned a different way.
I'm going to think about right in Worcester, locally, St. John's Food for the Poor.
Right.
There, it's connected with St. John's Parish, and it is a program that takes all comers. You come in, breakfast, they give them lunch, they give them if they are working poor, they give them a lunch to take to work. All of that stuff, it opens up certain avenues for them now.
Right. Which is fantastic.
And that's what it means. So when we talk about this, when Allison and I talk about the SCOTUS Bowl, okay, yeah, this is all interesting stuff, but what does it mean for me? That's what it means there.
And I mean, I guess you can look at it from the standpoint where people will say, well, I'm a taxpayer. I don't want to be forced to support a group or a view that I object to. But this clearly, you have to remove some of those layers to say, what was happening here? We're providing a safe playground for kids, right?
Yeah,
Number one.
period.
Number two, we did everything right. We weren't asking for favors. We submitted our application. We were first in line. We why would we be denied based
Right.
on that? So I think that was interesting. And then that turns over to this other case, an ERISA case. This is an important one, Jim. You and I spoke about this one as well, I think back maybe in early fall. And we were trying to get to this before the travel ban and then before the Comey story and then everything
Yeah.
else came out. Okay, so this was Advocate Healthcare Network versus Stapleton. This was also a church question, a church-affiliated hospital. They went ahead and they had a plan through ERISA in which they were trying to provide certain benefits. And because of the fact that they are associated with the church, essentially what ended up happening was the church itself didn't want to comply with a lot of these different laws.
Yeah, weren't they a Catholic
Yes.
a hospital?
Yes,
Yeah.
exactly. So the idea of a church-affiliated hospital having to kind of comply with ERISA was, in a nutshell, completely onerous. It was completely onerous because ERISA rules, which are designed obviously to ensure that pension plans don't go broke,
Yep.
and that they protect like the plan's beneficiaries, can be exempted if if it's dealing with church plans. And so this was one that I wasn't sure of how it was going to go because I felt that the court was going to look at it and maybe say, well, we've got these plans in place. We want to protect the plan's beneficiaries. We understand that there's an onerous on the church for having to comply with all of these different ERISA laws, but at the same time, are we exposing the hospital employees to maybe making, career-long contributions and then losing all of their money? But the court came back and they said, look, we're going to read the law, and we believe that there was an exemption for churches or affiliated organizations, and this hospital falls within that exemption, and so therefore they do not have to comply with ERISA.
See, now, that's huge.
Right.
What was the vote on this one?
8-0.
Yeah. See that? That's huge.
Right.
And to me, that's reading the law and following, pardon the pun, the letter of the law.
And that's what they did. And I
Yeah.
think, and Kagan actually she was the one that had written the opinion of the court on this one. And they said it was like one of her PowerPoint slides. Like she was in her full-on teaching mode when she was talking about it because she looked at the law and she said, well, here's what the law says. Let's deduce it. Let's look at it. Let's break it apart. Very simply, we come down to the point where there was an exemption, and that exemption specifically said that if in fact you were part of a religious organization, that you didn't have to comply with ERISA.
That kind of logic is what Neil Gorsuch expressed, and we got to get to break here.
Right.
Here to the news. Neil Gorsuch expressed. He said when they kept pushing him on that case where the man was in the truck, and
Right.
he said, "Look, write a better law. I'm just doing basically interpreting. This is whether or not this is the law that you have. Fine, you made the law. I'm interpreting it.
Right. I may
If
not
you don't
even like
like
the
it,
ruling.
right,
I may not even like the
and
ruling
that's
as
what
the
he
judge.
said.
But
That's
then it's a good decision.
But I've done my job.
Exactly.
Somebody has a question about the 9th, and it's a very good question, and we're going to hold it over. I'll ask you the question, but I think it's great. But we're with Allison Cohen. This is our SCOTUS Bowl. Don't forget, she is the host of Legalese every Saturday at 11 o'clock. She'll be live tomorrow on TAG and with the iHeartRadio app. Don't go anywhere. News with John Bayback next. You're listening to The Jim Polito Show, your safe space.